aims, and writing it down, can't stress how important it is to write it down, is really important. And actually, at the outset, when people are really enthusiastic about people, capturing that enthusiasm is often quite easy. But it's great when things get a little bit harder. It's a document that you can always go back to and go, well, actually, why are we doing this? What are we trying to achieve? Who are we trying to help? And it can really help sort of reinvigorate things. And after all, if you write it down, people do tend to do it. So you're much more likely to succeed if you understand why you're trying to do something, what you're trying to do, and what you're trying to achieve. Now, the what is always really, really hard, and someone can say, right, I want to do for instance, community garden. There's quite a lot wrapped up in those words, community garden. Mostly practical issues, but it's sort of, well, what do we need? Where were we thinking this is going to go? Is it going to be a community? Again, I'll use that community garden example. Is it going to stay the same size forever, or is it going to grow? Is it going to just be for a certain area of the locality, or is it going to be wider? Is there going to be a thought about, well, maybe we can generate some income from selling produce to local restaurants, cafes, etc.? Is a possibility in the future of a cafe, for instance, on the site? So thinking about all of those things, obviously it's really important to be sensible at the outset, but having an eye to where things might go in the future is very, very useful when you come to actually start to negotiate and look at what you want to occupy. Practicalities are things like buildings. I mean, that might sound very mundane, but if there's a building there, is it big enough? Is it secure enough? Lots of sort of charitable organizations do actually have lots of hand tools, some power tools, lawnmowers, chainsaws, all those sorts of things, and they're incredibly nickable. So does that buildings provide adequate security? Because there's nothing worse than turning up to to do a job and find that the one thing that you need to do that job has been pilfered in the middle of the night because somebody's decided to break in. If there's no buildings there, can you actually, and you need a building, can you put a building up? Do you need to put a road access in, hard standings? There's little point potentially on doing something in a field for people with disabilities who may be wheelchair users if they can't actually get around the site. So what do you need to do to make sure that you can do those sorts of things like hard paths, different road access? Can people get in easily? Funding as well, I think, is often forgotten at this point. There's a lot of excitement at the beginning, but how is the organisation, whatever it is doing, how's it going to be grant funded? Is it going to be grant funded rather? If you're going to go off and say get a grant fund and you need a lease of 15 years in order to qualify for that funding, if you then enter into a lease that's 5 years, you're already cutting yourself off for that funding. So really understand what funding restrictions may apply to what you're doing or what you're going after. Think about how you're going to achieve a way of running the charity or whatever it is you're doing, and how that is going to pay for itself. Because if you're setting yourself up and you're going to be 100% reliant on grant funding, you want to make sure that you are going to qualify for those grants when the time comes, and that will often be after you have entered into the lease or license to occupy some land. There's also the element of, at this stage, it's really good to start thinking about operational risks, safeguarding security. I've touched on security already. Yeah, that's physical security. Operational risk is fairly straightforward. If you are doing let's say, again, a market garden, maybe you're going to have a cafe in there or selling. What are the operational risks of doing that? So you have people using power tools, rotavators, maybe. Actually, the use of hand tools can be, if you leave a rake lying on the floor, if somebody steps on it, it does hurt. I know from experience, and probably many people do as well. You also need to think about safeguarding. Actually, that road access issue and safeguarding can also be an issue. If you have a safeguarding issue, how easy is it to get in or out of the site? Now, none of us like to think about the nasty things that go on in the world, but unfortunately, we have to. And certainly, as a lawyer advising charitable organisations, particularly ones where they are dealing with vulnerable people, it's a really important question to ask. And this is not just this is not because anybody's accusing anybody of anything, but those safeguarding issues, when they occur, they can be totally detrimental to whatever it is that you're trying to achieve. So you have to have an eye at all times onto the, for want of a better name, brand, the positioning of the organisation locally, and how it is perceived. Its reputation is really important. There's also sort of local and planning issues and other restrictions. If you are in the middle of an area, you're operating inside, say, an area of outstanding natural beauty or a national park, there are going to be much stricter restrictions on what you can and can't do than if you are, say, urban regeneration, turning waste ground into something. But equally, if you're turning waste ground into something, you obviously got to think about what that waste ground was used for beforehand if you're going to do something which is going to generate food production. So that whole question of what is really important. Once you know why you're doing it, you have to understand how, what you're going to do and what operations you're going to do. Once you understand that, that then really feeds through into where. And I think this question actually is often overlooked by people. They just go, right, we've got this idea, we understand what we're doing, now we need some land. And they just go and find a block of land, and it may or may not be suitable. And there could be all sorts of issues for that. I mean, for instance, is the if you're looking at a block of land, do you need to be near a particular area? If you are providing a particular facility, or you're doing care farming, for instance, is it in an area which is easily accessible? Is it near the people who are going to use it? Because obviously, if you're pointing it at a particular set of people, and you are miles away from where those people are, and they have restricted transportability, they're going to find it hard to get to you. So you need to think about that. Access, again, we sort of touched on this. How are people going to get to you? Much land is, once you get out of an urban area, or even in an urban area these days, there's no bus route. There's very little in where bus routes. Can people get to you easily? If you are, say, operating in rural Devon, you have people trying to navigate down very narrow lanes to get to you. Is that right? Do you need something closer to a main road? And you also need to think about the characteristics of the land. If you are doing something with people who have mobility issues, having land on a steep or having steep slopes around the place is probably not really advisable. So you need to do sort of quite significant landscaping, or try and find something that is flatter. And again, thinking about the people you're trying to attract and deal with and relate to, and what their needs are in relation to the service you're providing. And as I say, that I have seen it before, where someone has said, oh, we're going to do sort of community garden. We're going to try and do get lots of people who are physically disabled out to do gardening and to do something, and they've taken a lease of land, 3/4 of which is sort of on a 1 in 5 slope. Well, it's very pretty and it's lovely, but actually they basically made most of their land unusable for their people they're trying to reach. And then again, thinking about the land as well, there are environmental issues which are really obvious to I mean, maybe really I'm very lucky. I'm growing up on a farm, but they are obvious to me when I sort of stand there and look at it. If you have land that is in a valley bottom and there's a stream running through it, how likely is it to flood? If it floods, does that affect what you're doing with it? Does that mean that you can't use certain parts of the property at certain times of the year? Does that mean the one is the one place where you might be able to put the shed up the one place that gets flooded every winter? Those are questions that you can ask, and there's things like the Environment Agency flood map, which can help with those. But just asking those questions of people with local knowledge can be very useful. And you have pollution and contamination, and this is probably more relevant to urban sites. But if there is a patch of waste ground, what has it been used for previously? And you can find out a lot actually on the internet. You can Google it. You can find out what the factories were going on old OS maps, etc. So there's a lot of local history will be very helpful. But if you have a patch of land and it was an old town gas works, the likelihood of being able to successfully grow produce and sell it and eat it and not get ill is very low, because there will be all sorts of contamination sitting in the soil which the plants will absorb. So thinking about that sort of issue is really important. Now, if you're doing just a garden which is going to be ornamental, but the idea is to get people out and growing flowers, and then that might be less of an issue, although you still might have an issue with pollution, but it could be less of an issue. But thinking about that pollution, contamination, flooding, if you're buying if you're renting or leasing a block of land that is right on top of a moor, gets very windy, and so you'd have to think about, well, how do we make sure our rubbish or our buildings are secure against damage from the wind? So just thinking about those environmental issues can pay dividends later on, because you'll be prepared for ultimately what nature throws at you. So we sort of get to the real guts of the sort of talk now, really. Sort of sit and talk about this for sort of the next 20-25 minutes, and it's the how bit. Once you know what you want to do, why you want to do it, and what you want to do, and where you want to do it, you sort of naturally come through to how are we going to do it? I mean, any sort of keen observers will have seen I missed one question off, which was when. Unfortunately, I can't, as a lawyer, I can't help clients with when. Really, it's whenever you sort of are ready to do it. But how is massively important, and really the how starts with structure, and what is the right structure for any individual charity or other organisation is going to depend very much on what it is, what it's trying to do, and where it is. Traditionally, charities have been unincorporated, and by that I mean they've had no separate legal identity away from the trustees. Now, in past times, when charities were mainly concerned with just the collection of monies and then the distribution, that didn't pose much of an issue, because there was little in the way of, as long as they did what the charity was supposed to do, i.e., collect money and fundraise, and they distributed it in the terms of the charitable trust or however it was set up, then there were no problems. The difficulty with unincorporated is that these days is the issue with reputation. again, we come back to safeguarding. I can't remember the name of the charity 4 or 5 years ago that really got into trouble with it. It'll come back to me. But if you are a trustee and of an unincorporated charity or other organisation, you are personally liable for what goes on in that organisation, whether you knew about it or not. So if you had, let's say there was an employee and they were embezzling funds, the trustees in the first instance can be made to go and make good that loss personally. So that means the trustee sticks their hand in their own pocket, and it might be one or more of the trustees. It's joint and what they call joint and several liability. Now, in that instance of criminal wrongdoing, there may be then a restitutional claim by the trustees against the employee, but ultimately it is for the trustees to make good the loss. If you are an organisation where you are, have employees, people who you are dealing with, say on a care farming or a social gardening sort of arrangement, or where you have people coming to the site to do things for therapy or other reasons, then being unincorporated, I'm afraid, is really bad news. The incident liability that sits with the trustees is gigantic, and when I say potentially reputationally damaging for that individual, so for instance, me as a solicitor, if I was a trustee and that charity, a charity I was a trustee of, got into difficulty, then I might, depending on what exactly that difficulty was, I might have to report that to my regulatory authority, the solicitors regulatory authority, and they may take sanctions against me. So not only is it that personal financial a reputational issue, but you've got that a professional side of it as well, that you may people may find they have to report to their governing body. And so if somebody's a teacher and doing something, they may find that they are no longer able to be on the register of teachers or nurse or doctor or something like that. So it is really important to get it right. The alternative, and much to be encouraged these days, is some form of incorporated charity. Now, a charity can incorporate. You can have an incorporated charity. You can also have community interest companies and other organisations as well. But the difference to them is that they have their own legal identity. So, just to give flesh on the bones to that, if you are an unincorporated charity and you enter into a lease, the people who the names that appear on the top of that lease as the tenant are the names of the individual trustees. If you are an incorporated organisation, or incorporated charity, for instance, the name on the lease is the charity, not the trustees. And there's a big difference there. It makes things easier from the point of view of limiting liability for the individual trustees. It also, from the point of view of the charity as well, it makes dealing with property and other matters very much easier. Because think about employees. If you have I keep using the word charity. That's just for it's an all-encompassing term. I don't mean just charities. I mean all the entities that can be in this space. But if you're unincorporated, and you have employees, then it is the trustees individually and together who are the employer of the employees. If you're in an incorporated organisation, then it is the incorporated organisation that is the employer. And again, that makes life very much easier when it comes to dealing with changes on the trustees, because if you start something with trustees A, B, C, and D, and then 5 years later, and they enter into a 10-year lease, and then 5 years later, A, B, C, and D, D decides he's had enough of being a trustee and it becomes A, B, C, and E. Technically, you have to transfer the lease from the original trustees to the new trustees. With an incorporated organisation, you don't have to worry about that. So actually, as well as sort of a lot of protectional issues for the trustees, being incorporated does make life and dealing with things like leases and other contracts and funding that much easier to do. So once you've got the sort of the overarching identity of the organisation enter into it, we then have to think lease, license, or joint venture, and actually they're very, very different. I'll go on to sort of lease, go on to these a little bit below, but they have very different characteristics, and it's really important to understand what it's, what characteristics will really help drive the organisation's ability to achieve what it wants to achieve, because you may find that actually some form of joint venture might give you a better ability to achieve what you want rather than a lease or a license. So lease, licenses and joint ventures can effectively be sort of looked at in these ways. A lease is a very specific legal construction. It is something that provides exclusive possession to a tenant for a term certain. So that is, the tenant has, the landlord has no ability or very limited ability to just share occupation. Now, the landlord may be able to come on to do certain things, such as inspect or to make repairs if the tenant hasn't done them, that the tenant is obliged to do them. But ultimately, the tenant is able to exclude the landlord. Those words term certain, that just means it's for a defined period of time. And there's lots of case law about what term certain is. And they range from, you can have what's known as an annual periodic lease, and that's one that just rolls over from year to year. We're probably all happy with a lease which is 5 years, 10 years. It is possible also to have, there's lots of case law about leases which were granted for the term of the Second World War in the 1940s and 50s, and leases granted for life. So we're very used to a 5-year lease, 10-year lease, 15-year lease. One of the interesting things, and this is often forgotten, is that you don't need to have a passing rent for there to be a lease. So you don't actually need to pay rent. There should be what's known as consideration. So if you ever get to a position where the landlord is saying, I'll let you have this for your charitable purposes for 15 years, but I don't want any rent because that's my giving back to the community, we'd often stick in there what's known as a peppercorn, and that literally is, if your rent was demanded, you would have to hand over a peppercorn, and yes, I do mean the little brown spherical things you grind up and put on your food, to the landlord. And the reason for that is quite historical, but spices used to be very valuable, and so if you wanted there to be consideration for something, but you didn't want there to be any money changing hands, you would refer to it as being a peppercorn. So technically, the landlord has consideration in that he can ask for a peppercorn which has value, but ultimately he's not going to do so, because what can you do with a peppercorn? You might be able to season something once, but that's it. And so that's where a sort of a peppercorn rent comes from. We tend to put £1 these days because it's a bit more relevant to this day and age, and nobody really wants £1 because its value is purchasing power is not great. A license is to be distinguished from a lease because there is no exclusive occupation or exclusive possession by the tenant. So if you are sharing a possession, then you've got a license. And a joint venture is actually that. A joint venture might be two charities coming together and saying, we've got similar outlooks, let's pool our resources and do something. But that is doesn't confer any occupational rights of land or otherwise, and that is actually literally as it says. The main types of lease we also look at with charities on this sort of arrangements are either a farm business tenancy or what we call a 54 Act business lease. So a farm business tenancy is governed by the Agricultural Tenancies Act 1995, and that is very specific. You have to match the statutory requirements, and there's lots of things you can't contract out on a farm business tenancy. You can, however, start with a farm business tenancy, but end up with a business lease, so 54 Act lease. So that's a tenancy under the Landlord and Tenant Act 1954. I'm not going to go any more into the details of those, but suffice it to say, understanding what your tenancy is important because they provide different rights to the tenant and the landlord. If you have a 54 Act business lease and it is not contracted out, you have very significant security of tenure. There's also some security of tenure under a farm business tenancy, but it's highly specific to the relevant circumstances. So once you sort of know what you're going to do, know where you're going to do it, know how you're going to do it and how you're structured, then you sort of go out, find a piece of land, and then you start to negotiate with either an agent or with the landlord direct. So the first document you're going to get to is heads of terms, and these will be negotiated. They'll be known what's subject to contract. So that's i.e. the heads of terms are not a binding contractual agreement between the parties. And they should set out everything that I've got there. So the type of the arrangement, the property. Surprisingly common when we see some heads of terms that it's not clear what the property is. Try not to go for straight descriptions. Try and have a plan. Try and have a good quality plan for a number of reasons. But being absolutely clear about what is being let is really key, because some landlords, particularly if they're not got an agent acting for them, can be a bit woolly about things. And unfortunately, with property law, detail is really, really key. The heads of terms should also set out the term. And again, linking this back to what we were talking about earlier, is saying, is this long enough for our funding requirements? If the funding we're looking at requires us to have 15 years, can we have 15 years? Just watch on that, because of course, it sort of comes into anything else. If the landlord agrees a 15-year term, but they have a break clause at 5 years or 10 years or both, so that is, they can serve notice on you to break the lease, so to bring it to an end, you're probably not going to get funding. So really watch the impact of break clauses, both on your side and the landlord's side. And I would certainly try, if the landlord is insistent on a break clause, then really ask why. Because break clauses will mean that the landlord can bring the arrangements to an end very quickly, often on 6 months' notice, and you will lose the tenancy. So really think hard about any break clause and I would suggest trying to resist them. Rent review, fairly obvious, obviously how much you're going to pay, if the rent is going to be reviewed, how often, on what basis. I would recommend, if you haven't got access to a friendly surveyor, the surveyor is helping you with some of these things, to think about it. Permitted use. Often a tenancy or license will say what you can or can't do on the tenancy, on the land. So if you have a plan that says we're going to do some community gardening and eventually hopefully get to a cafe where we will cook and sell food we've grown on the community garden, then if your lease says you cannot run a cafe, you can only use it for a community garden, you've got a problem. So think about those permitted uses. There is something in the drafting of leases called absolute or qualified consent. So absolute refusal or consent. If you have a permitted use and it says thou shalt only use it for X, and you want to use the land for Y, if you go to the landlord and say, please can I use this land for Y, he can say no, and he does not have to be reasonable in his decision. If you have wording which basically requires him to give consent to any alternative use, such consent not to be unreasonably delayed or refused, then he has to give a reasonable reason for either delaying or refusing a request to change the permitted use. But that's really important. Alienation, is probably not going to be massively important, but alienation is what is around what you can or cannot do with the lease. So if you are the type of, I did one for Dartington actually, I think they were letting to somebody, and then somebody, and their intention was always at the outset to sublet to a local charity that had the same aims as them. If they'd have actually told us that at the outset, we could have saved everybody a huge amount of money, because the client didn't mind. It was absolutely fine. But actually, if they'd have been a bit more open with the landlord, we could have actually set it all up so it was very much easier to do that subletting. So if you think you're going to want to sublet, or you might need to assign it, then talk to the landlord. If you are an unincorporated charity for some reason, then you need to have an alienation clause which basically permits assignment on change of trustees without having to go to the landlord, because then again, life is a lot easier. Consents for works, if you want to do hard work, hard engineering works or buildings or anything, you need to, and you're going to do it, you need to get it in the heads of terms at the outset. And I've put a very unhelpful anything else at the bottom of there. Basically, the heads of terms are the broad commercial agreements between the parties. It's important not to get too bogged down with heads of terms, but if there is something important that you need to do on the land, or in relation to the land, because of what it is you're trying to achieve, it needs to go in the heads of terms, because it is because we lawyers, we love arguing about stuff, and if it's not in the heads of terms, we'll argue about it. That doesn't help anybody, frankly, at all. So if there is something really important, and it might be, for instance, a really good one to think about actually is often landlords will reserve a right to go on the land on giving notice in order to inspect. What you may say on there is, okay, you may want to put in there and say, anybody from the landlord coming on to anybody on behalf of the landlord or the landlord themselves coming on to inspect anything must, for instance, have sorry, I'm going to get it wrong now. It was DBS when I last had it, but the criminal sanctions barring service. Somebody may need to have that. And if that's important because of what you're doing, then that needs to go in the heads of terms. So think about some of those things which really are important to you, because of course, if you have a breach of, if for some reason something happens because the landlord can do it in the lease, but it is an effective breach of your safeguarding policy, for instance, then the person whose problem it is yours, not the landlord's. So think about those sorts of things. Sorry, there we go. Have I gone? Yeah, sorry. Some other things to consider when thinking about your negotiations with the landlord. Title is one that comes up time and time again. Normally, when we're dealing with registration, I'll talk about registration in a minute, but title is really important because you can only take a lease from the person who owns the land or has a lesser title or has a legal title in the land, such as another tenant. So if your landlord or the person you're dealing with is not the registered owner or doesn't have the title deeds, then they can't let you the land. I know it sounds trite to say it, but it's really important. Similarly, because some of the care farms and some things that I've seen have been diversification projects is wrong, but they are farmers who are doing something extra and giving something back to the community. Now, they may think the great idea to do a community garden and rent an area of their farm to a community garden, but if they're tenants themselves, their tenancy agreement might not allow them to do that without landlord's consent, might not allow them to do it at all. So again, checking that title, understanding what the person who you're dealing with can or can't do is really important. Searches. Anybody who's bought a house before will know we solicitors love our searches. That's local search, water and drainage search, environmental search. It shows what's wrong with the place, frankly. I mean, there's lots of ways of looking for information anyway online. So you can always do say a planning search on a portal for the local authority just to see what's been done there before. What you can't get is though online is a lot of answers to what we call pre-contract inquiries. So these are in effect a standardized set of questions which are asked of a seller or a landlord before entering into a contract to find out about the property. I mean, typically the important ones are there any disputes, and have there any notice been paid? The last thing you want is to suddenly find you are lumped into the middle of a dispute over, say, an access to a field, which you didn't know about, and which the owner of the access has decided to barricade with several tons of concrete, and you are stuck. And what are you going to do? So those are the sorts of things that it would pick up. Local and statutory restrictions. I've already picked up a little bit. National parks, areas of outstanding natural beauty. I've got that wrong. It's ANOB. That is ANOB. They can be. I'm just thinking back to dealing with Dartmoor National Park. They tended to answer no and then ask what the question was to anything. So you do have to be a little bit careful with parks authorities, and I would suggest, if you're thinking about doing something I would suggest early engagement with those authorities to talk to, say, the local ranger or something like that, because if you can get them on side early, it will make life a lot easier. So I just want to also just go back to sort of local statutory restrictions. The other thing on local is have a look through some old plans. You can go online and you can see old OS plans, and it's amazing what you can see and how places have changed. And for instance, I mean, it wasn't a charity client, but I bought a block of land for a client once, and they actually wanted to put a vineyard on it. And we dug around a bit and we found out that it had been previously used for a clay pigeon club range. And we got a bit of information about how often the club shot there and etc. And we worked out that there was about 1.5 tons of lead in the ground. Now that's quite an extreme example, but just a little bit of digging on the internet locally, if you know people. Another great, a good example we got was, again, it's not a non-charity client, but buying a block of land for a client. We turned up some old OS maps, and there was something called a burn. There was an old ruin on the land. He said, "Oh, it's just an old barn." We looked, and it turned out to be an old burning house. Now, a burning house is where they used to take tin ore and burn the arsenic off. So we suggested that he get a slightly more invasive environmental search done. And yes, true to form, the area around it was absolutely laced with arsenic, which, given he had an idea of turning the place into a holiday cottage, didn't seem to us to be a terribly good idea. Last 2 bits on this: registration. Now, when I'm talking about registration, I mean registration at the land registry. Any lease over 7 years or 7 years or longer in length has to be registered at the land registry. That means that the lease itself must have what are known as the land registry prescribed clauses on it, which are a set of prescribed clauses at the beginning of the lease from the land registry. This really is where
okay. Sorry to interrupt. Yeah.
This is really where the title comes up to, because often the first we know about these sorts of arrangements with our clients is when they ring us up and say, "Can you register a lease for me?" And then we go back and we check the title and we go, "You do know your landlord is not the person that owns the property." And we spend time sorting it out, time and money, I would say, sorting it out. But if a property document is registrable, if it's compulsory registrable, and there's a list of what is compulsory registrable, the document itself is of no legal effect until it is registered. So it's really important to be on top of that sort of thing and understand if what you're doing is registrable. Now, the rule of thumb is anything 7 years or over is registrable. Anything 3 years or under is not. There's a bit of a grey area between 3 and 7 years because of easements. Because the easements, the lease itself may not be registrable, but if you have an easement over another parcel of land, that might be registrable. So it's important to just take care around that and understand where it may be. Lastly on here, we've got stamp duty land tax, SDLT, and land transaction tax. So I should have said at the beginning that what I'm talking about, although some of what I'm saying is applicable no matter where you are in the country, the legal bits are relevant to England and Wales, not Scotland or Northern Ireland. Stamp duty land tax and land transaction tax are effectively equivalent. Stamp duty land tax is in England, land transaction tax is in Wales. There are often exemptions for charities, so it's not necessarily a huge concern. But if there's no relevant exemption, there can be filing requirements even if there's no tax payable. And those filing requirements can be quite strict. Typically 14 days after the date of the date of completion of any agreement. So again, really important to understand that position before completing, so that anything can be done immediately after completion. As I say, even if there is a relevant exemption, you probably still have to submit a return. So if there isn't a charities exemption, you do qualify for, say, the charities exemption, you might still have to submit a return. And it's important that return is submitted on time, particularly as actually if the lease is also registrable, for instance, as a lease, you can't register it until your SDLT or LTT return has been made and you get a little docket from the relevant authority. Just a point to note, licenses are not taxable for either SDLT or LTT because they don't transfer what's known as an interest in land. This is where it comes back to that point about licenses sharing occupation. Again, if a landlord is talking about a license, or a landowner is talking about a license, and you have strict requirements around safeguarding, licenses are a really bad idea because you'll not be able to exclude the landlord. So that's me done for what I had to say, and hopefully that has left us with 10 or so minutes, 10-15 minutes to have some questions.
Yeah,
I'll
great. Well, we've got
sharing that.
Thanks, Joel. We've got a few questions lined up for the next 10 minutes. The first one was from Mal Davis, who I know they're based up Pontypool Way in South Wales, and they're looking to take over an ornamental garden, green space from a local authority, and they were asking if they should expect any types of concessions from the local authority because it is a community-led project. I'm presuming they mean in terms of rent, but I've gone back and asked if there was any other thing, Mal, that you were thinking of. That's the question. Any things that the local authority should be giving to the group because they're obviously providing a community service and managed in the park.
I suppose the best way to put that is, my hope is yes. My heart says yes. My head says no. The local authorities have been under huge pressure, particularly over the last 9 months, obviously, but even before that. So we often get, in fact, actually, we last year, was it last year? Yes, last year we sorted out some management agreements between a local authority and a local wildlife charity, and you'd normally think you are taking effectively potentially taking cost away from the from the local authority and taking liability away from them. So that should have a value. Unfortunately, the local authorities aren't necessarily on the same page in relation to that, and they are it's very hard. Having a good relationship with them is really key, because then they can see making them see the benefit they have. But I would say probably just be prepared for them to potentially be difficult, at least at some point during the course of discussing and negotiating it.
Yes. Well, obviously, they don't have to get X value for a community-led project. They are allowed to sort of provide a lease to community projects if there's environmental, social, and economic reasons why they could do that. So they could, in my experience, have the peppercorn rent at the very least. Yes, they're always acting in their own interests rather than safeguarding their position, I suppose, aren't they, in these lease arrangements?
Yeah, I mean, so they hate being criticised, and they think that criticism can be averted by having as close to commercial terms as possible.
Sure. Okay, that's a good way of looking at it. Getting through quickly then. Ed Humphrey has asked, what does consideration do for the arrangement rather than something that's consideration free? So again, about the rent.
Oh God, that's a highly technical law school question. So the consideration, when we're talking about consideration, we're talking about money or money's worth, and actually the point around consideration is purely around is actually a highly technical area to do with whether a document can be a contract underhand or a deed. A contract underhand is just signed by the parties, and that's it. And try to think of an example. So technically, when you are in the supermarket and you take an item off the shelf and place it in your basket, at the point where you put the item from your basket onto the conveyor belt at the supermarket checkout, that point is known as your invitation to treat. So that is between the parties an idea of the supermarket is saying, we will sell it for this price, and you're saying, well, I might buy it for that price. At that point, there's no contract arisen. As it moves down the conveyor belt and it's scanned by the checkout assistant, at the point where it goes blip, and it goes on to your onto the tally, as it were, that's at the point where the contract is formed. So you have agreed at that point potentially to buy it, and then when you pay, the contract is completed. So that's really, so where it's your payment, it's your handing over of money, which is your consideration. Now that's for contracts out of hand. Deeds are slightly different. You do not need consideration for a deed. So a deed is a document which is both executed, says it's a deed on the top, is executed as a deed, and is delivered. Many people will probably remember the old saying, signed, sealed, and delivered. That's because you used to sign and seal a deed. You don't have to anymore, you just execute it. So that's the difference, really. When, as I say, we often do get, we'll get heads of terms in for something, and it will say the rent is nothing. And just as a matter of course, we will stick it in as a peppercorn, because it just makes everything, from a legal point of view, if we can show there is some consideration, we have two arguments, both that it's a contract and that it's a deed. And we have different avenues for enforcement should that be necessary. But as I say, whether it's a rent of £0 or a rent of £1, they will actually effectively amount to almost the same. And as I say, it is for highly technical legal reasons that we will often take a rent as zero and make it a peppercorn or a pound or even just a penny.
But they don't have to part with that many.
No, because because it's such a trifling amount. Is say it would be the wording in the document would be, if it was a peppercorn, you say a peppercorn if demanded. So it would only be if the landlord came along and said, "I want you to pay me your rent." Would you actually physically have to hand over a peppercorn?
Okay.
But the point, it's slightly anachronistic, but it's the same if it was a pound or a penny. The point is that it's such a trifling amount, the landlord's not going to do it, because to do it is going to be it would take more in both time and money to demand it and deal with it than it is worth, and that's really the point. But it's still money or money's worth, which is consideration, and so it still counts.
Okay, thanks. We're running out of time. There was a couple of questions around from Shannon Williams about difference between incorporated and incorporated. I deal with that sort of question on a daily basis, so perhaps I will answer that on email. But one of the more interesting sort of questions that you might be able to shed light on was expand on break clauses. And also thinking about whether when a bit of land is gifted to the community for sport and recreation, could you interpret that to be perhaps for an orchard or a forest school type use? Right,
I'm going to deal with that one. I'm going to deal with that one first, actually, and then I'll come back to break clauses and you say them. Where land is left, you've got to be a little bit careful, because there are a couple of really nasty little short acts from about 100 years ago called Reverter of Sites Acts. They primarily used to refer to when the local lord would leave a building or a block of land for the purpose of his school. But it can also apply to religious and other religious buildings and other buildings. And when that use that it has been gifted for ceases, then it reverts back to the person that gave the gift or the successors in title. So if it was an outright gift to, example, it was a gift to the local authority for the benefit of the people of Cardiff for the purposes of sports and recreation, then there's probably some, depending on the precise terms, that there is probably some latitude for the local authority to decide what amounts to sport and recreation for the people of Cardiff. I'm not saying that everybody would agree with that, but there's probably some latitude. If it was left in a different, if it was left in a different way, the reverter acts applied to it, then depending on how prescriptive that use were, if that use stopped, it could mean that the land reverts back to the person that, or the successor in title. So that's it is actually a really complicated position, and I've had the benefit actually of having, mostly from the landlord's point of view, acted on a couple of sites where that is applied, and we've got the land back for the, it's like, oh, I've got the land back for the estate, but it's highly complicated and would need to be looked at very, very carefully. Break clauses, permitted uses, and absolutely consents. So permitted use is just a label we place. So in any document it'll be defined. So the permitted use will be, and then it will set out a number of permitted uses, and that can be anything, as long as it's not illegal. Then
I often suggest that groups should ask for as general a sort of clause as possible, so to make it as wide as possible, so that like if they're wanting to perhaps have chickens on site or something like that, so make sure it doesn't preclude, you know, having chickens or livestock.
Yeah, and I think that you've got to sort of make sure, and this is one of the things, that make sure that the use clause, what we call the use clause, so that's what you can do and can't do, is not impacted by covenants contained elsewhere in the lease. So you can sometimes see a covenant that's separate from the use clause, which says not to keep animals on the property, and that's a sort of a general restrictive covenant. But yeah, so what wide it's very, this is where the lawyer bit comes in. You often want to be vague, you know, on these sorts of things, depending on what your position is, you might want to be both vague and precise both at the same time. I'm afraid that's terribly unhelpful, but it is it's very hard to think of a description of what that might look like. But you start with, what do you want to do? What does the organisation want to do, and what it might want to do in the future? You know, what its expansion terms are, and then you try and shoehorn that into the wording. And this is where we get to, you know, in the initial discussions with the landlord, you want to be quite upfront with them and say, right, we want to do this, but this is where we want to go in the future. And this is what we want the ability to do without having to come back to you too much about it, and have that understanding. So on the consent wise, although there may be a clause in a tenancy agreement which says thou shalt not use it, thou shalt not use it for the keeping of animals, for instance. That does not mean you cannot ask the landlord to be able to keep animals on the property. What it means is the landlord can unreasonably refuse to give you consent. So they don't have to have any reasonable reasons. They can just say no. Of course, they can say yes as well, but they are able to say no. The qualified version of that is, thou shalt not keep animals on the property without the consent of the landlord, such consent not to be unreasonably refused or withheld. And it's that reasonably refused or withheld which is the important bit. So you go to the landlord and you say, right, as part of our overall thing, we want to keep 6 chickens because it's good for the ground and all the rest of it. This is the reasoning. If the landlord says no, he'd have to have a really good reason for that. If you said, yeah, we're going to keep 100 pigs in the area rather than what we're doing, you probably have a reasonable reason to say, no, that's just overstocking, you can't do that.
Yeah.
That's wrong. But so it's that reasonableness, you know, it becomes a question of reasonableness, and that's the same throughout anything in the document. So anything whereby, you know, it's what we call an absolute prohibition or an absolute on it, the landlord can unreasonably refuse. If it's qualified, then they have to be reasonable. And you can make things, and that's part of the skill in drafting, of picking out the bits which are really important for the tenant to make them qualified, to give them that ability. But also, you know, the importance of the heads of terms to set out, you know, the things that the tenant can and can't do. So if there is something really important to the tenant for what you're trying to do, as I say, you know, a really good example is if you've got a piece of bare land and you need to put a shed up. You know, you'd want that at the outset. You'd want to have to say, yeah, and we can put a shed up of X size.
Yes.
Or whatever. You know, putting that in the heads of terms.
Great. Thank you, Joel. I think we're going to have to leave it there because we've run over time. But some of that stuff was very interesting and very useful, actually. I think I've consumed as much of it as I can and written some notes down. If people haven't had a chance to have their question answered, apologies for that. If you drop me an email, lucy@farmthegarden.org.uk, I can do my best to answer it, and I'm sure Joel would.
Yeah, I'm happy to have a look at anything, so don't worry about that.
Thank you. Well, thank you to everyone for attending, and thank you so much again to Joel and Wright Hassall LLP solicitors for this event this afternoon. All the very best to everyone. Thank you.
Great. Thank you very much, everybody. Bye.
Bye.